would have our moderated session. And then, like I mentioned earlier, the panel members are Professor Akilagpa Sawyer, Mr. Ernest Kofi Abotsi, Dr. Nimoy Thompson, who is being represented today by Dr. Isaac Mensah-Bonsu, as well as Mr. Bryce Simmons. So I'll briefly go through their bios, which I actually mentioned to you earlier on, and then we introduce them on stage one after the other, their profiles. So beginning with Dr. Isaac Mensah-Bonsu. He's representing Dr. Nimoy Thompson, the Executive Director of the NDPC. Dr. Mensah-Bonsu is the Director for Plan Coordination at the NDPC, and he's coordinating the preparation of the 40-year long-term development plan for Ghana. Please let's put our hands together for Dr. Mensah-Bonsu. I believe you can take his seat over there. Thank you. Moving on, Mr. Ernest Kofi Abotsi. Like I mentioned earlier, he's a partner of Axis Legal with over 13 years standing at the bar. Mr. Abotsi is currently the Dean of the Faculty of Law of the Ghana Institute of Management and Public Administration. He has provided extensive advisory services to diverse clients, including the Judiciary, the Attorney General's Department, corporate institutions, amongst others. Please let's put our hands together for Mr. Kofi Abotsi. Professor Akilagpa Sawyer. He's a former Secretary General of the Association of African Universities. He served on the Council of the United Nations University and the Board of the International Association of Universities. He's a former Vice Chancellor of the University of Ghana and currently serves as the President of the Ghana Academy of Arts and Sciences. Please, let's put our hands together for Professor Akilagpa Sawyer. And finally, Mr. Bryce Simmons is the founder of the mPedigree Network, one of Africa's leading technology businesses, specializing in the use of mobile and web technology in the detection of counterfeit products. Please, let's put our hands together for Mr. Bryce Simmons. At this stage, I'll humbly hand over affairs to our able moderator. Mr. Samson Lardy Anyenini is a senior partner at A Partners at Law, the host of Joy FM's Newsfile, and a communications consultant at Strategic Media and Legal Communications. Mr. Lardy's work within the media spans over a decade, during which time he has tackled some of Ghana's most critical issues. Please, let's introduce Mr. Samson Anyenini. Thank you.
Well, ladies and gentlemen, I believe that we've had a long day already, but this is the time that you cannot afford to blink. After having listened to the various presentations that they have given, I am sure that you are even more energized to listen to how they engage each other when it comes to some of the things that they had to say being questioned. But more importantly, don't forget the focus of this program or symposium, Laws That Work. I want to also say thank you very much for agreeing to be on this platform and to engage Ghanaians on the issues that matter the most. I'm clearly aware that what is going on today sounds to me like a program in an LLM class, Law and Development. It is a new path that even the World Bank seeks to champion in ways that appear to be an imposition. I want to refer to John Locke in one of his treatises when he said, even if the law in a contractarian legal system is so wicked to legislate against the interest of the people reserve the right to vote that man out of power what's the connection with this quotation to law and development and laws that work? The laws are about the people, and the laws are supposed to be for the people. Now, I want to begin with Mr. Abotsi, who had some very interesting comments to make, and he had indicated that some of the comments were to provoke, I will change what he said, to provoke some discussion. Now, Mr. Abotsi, you refer to the Supreme Court's job, or the job of the judge in interpretation and judicial activism. And you suggest that interpreting the laws to make law and policy may not be bad, yet it will be your preference that the judges will stay pure. Is that suggestion to the effect that you wish that the judges will not veer into the area of lawmaking or judicial lawmaking or interpretation? And if they did that, can you imagine what the situation will be? Because as we speak, we do not have a freedom of information law. It is taking a court, a judge, to say you have a right to that information in the public office.
Well, thank you very much, Mr. Moderator. First of all, I think I seized the opportunity of the presence of the Venerable Honorable Minority Leader to speak to Parliament on this, because I have to say that it has been a frustration of this country. I have attended countless events, spoken at many of these events, designed to get Parliament to pass the Freedom of Information law. Parliament has been present. Committees have been established. They've attended these. We've said all kinds of things. They eventually came to nothing. One reality was the fact that Parliament had priorities. And again, don't forget this. And I'm going to make this statement to them. I think today I'll end up getting myself in trouble. So let me just finish saying it. But, Parliament had apparently very little incentive in passing this. Because one thing we can't deny in this country is that the relationship between Parliament and the executive has been a negative relationship. Unfortunately, they mutually enjoy that. And because they mutually enjoy it, that is why, for example, constitutional provisions or constitutional proposals that have been made for the changes to be made in the Constitution has itself also partly stalled. Because all kinds of people are calculating all kinds of losses and benefits. And so the incentive is always minimum. The point I was making is that in an ideal world, the judiciary should have no business in policy. In an ideal world. And that ideal world is the judiciary will only deal with the law as the law. Let the executive and Parliament deal with policy. We don't live in an ideal world. We live in the real world. In the real world, there are policy gaps. In the real world, there are policy legal mixes. And if you take the Constitution, which many people see as a legal document, but which substantially is a political document, that document contains all kinds of policy prescriptions and policy statements. And the Supreme Court is supposed to interpret that Constitution. It is impossible to say that the Supreme Court should stay clear of policy and just interpret the law. It will interpret the law, but there are policy considerations. In fact, the directive principles of state policy was explicit when it says that the Parliament, the executive, and the judiciary shall take the directive principles of state policy into account in their various work. So even the Constitution prescribes policy inclusion in interpretation. But the point I'm making is, in an ideal world, maybe we shouldn't, because judges are trained to just be lawyers, and so to speak, or be legal. But we don't live in an ideal world, and they have to come out with outcomes that work, that are just. Invariably, they have to take into account policy.
Ladies and gentlemen, there will be a session where you would have the opportunity to ask the questions that have been bothering your mind, particularly questions that are related to the discussions that we are having, flowing from some of the presentations you have heard. Of course, Prof has not made a presentation, but some of you are quite familiar with him. And Prof, very recently, I was watching this video about the VALCO negotiations. Very difficult negotiations. and at that time you look much younger. And I discovered the clause that you used, including blackmail even, to get Kaiser off our backs to give us cheaper, cost of the electricity that we produce, or a good cost for it, because we're giving them too cheap. Now, my question to you will be, laws that work, having been a part of the legal engineering of this country for the last few decades, would you say that we have laws that work?
Thank you very much. Am I coming out clear? Yeah. Let me step back from your question for a second and to pay tribute to the Noble Law Group, the young lawyers and students who have worked so hard to bring us together. I had the privilege of working with them in coming to this pass. And I have to commend them for their enthusiasm and their public spiritedness. And as you implied about an old man now, I think seeing them work so hard as volunteers gives encouragement for the future from my point of view. So I thank you very much for what you've done. Congratulations. On the question of laws that work in my experience, as I listened to the range of presentations, I kept getting more and more lost because they've covered such a range of issues in such a variety of ways that it is not easy to engage directly. Let me illustrate that briefly. Bryce Simmons gave us an extremely interesting and impassioned account about the public interest, national interest dispute. But it seems to me that to really ground that discussion, you must also introduce the notion of social class, because you can't assume that the interests of all the people in any area are the same. And therefore, you will have to complicate the story a bit more. The national as against the outside, the public based upon that. But within the public, there are divisions. And so my takeoff, back to the topic, is to take a slightly lower profile and to try to look at the law as a social construct. And from that perspective, the law which we teach and study is set against the society from which it comes up and policy as well. So that there is a link between law, policy, and society. And that link is dialectical, which means that the law comes out of society and policy, and in turn influences society and policy going forward. That's the first point I'll make, that they are interrelated. It will be an error to separate them as we do sometimes. And that begins to deal with Mr. Abotsi's point about the judicial policy interventions and that whole delicate thing. It's unavoidable. But let me get back to another dimension. When we talk about policy, the question comes up, whose policy? Who develops what we call a policy on this or that? How is the policy arrived at? How is it followed through? What institutions, arrangements create policy and monitor it? And in all of this, what is the role of of the non-state actors, the citizenry. What is our role in policy making? That for me is a point which we tend to not address sufficiently as we go forward. We assume that the policy makers make policy. But unless the policy they make in some way reflects the concerns which justify their being put there, what's the point of it? So one of the things that I thought I should add to our discussion is on the question, how do we ensure the policy cycle is not left just to the policy makers? How do we do that? One of the ways clearly is to make information available as widely as possible about not just the policies, but their basis and their effect. Let me throw in one quick thing we haven't heard mentioned so far. And that is the issue of government contracts. Back to your VACO story. Our governments contract all the time. Procurement contracts, natural resource agreements, service contracts, all of these things are taking place in our name. And yet, how much do we know about these agreements? I was struck by the recent court decision compelling disclosure of the contract, which you mentioned, Mr. Abotsi. I would go further. One, remind us of the Freedom of Information Law, which is still dormant. Have you mentioned that, Ernest? But beyond that, there is a new idea emerging, that is open contracting, requiring of our governments everywhere to publish all the contracts they make on our behalf routinely, not on request, but routinely make available the terms of all contracts undertaken on our behalf. Let us think in. There are many things that will fall from this. One is to make us more aware of what is being done and put us in the picture of monitoring both the contracting and performance. The idea is not novel. It's been tried in some countries already. The problem that it poses includes, one, commercial secrets. Two, the privacy of those who are not themselves contractors, but whose information is in the contracts. And the third one is security, national security. There are things you don't want to disclose. But all of these can be dealt with without, for a moment, stopping the free access to public contracts on our behalf. If there were time, I could go into those details as well. But let me just throw this out to us to consider as an important point to drive, to put it better into the policy making space. Back to VACO and the experience of that period. People here are too old to remember VACO, but not too old to remember Goldfield's agreement that was made last week, 2 weeks ago. We heard from the announcement first in South Africa and subsequently in Ghana that one of our mining companies has been able to get from government an agreement, part of whose terms include a reduction in tax and royalties, and so on. Do we know why? Have we inquired to find out on what basis these things were done? Have our media show sufficient interest at a time when government is defending the process of reducing subsidies, increasing utility bills, they give a tax reduction to a company. Are we interested in that? So my point then goes back to what I said earlier, that if we can demand the contracts which our governments make and demand explanations and accountability, it will put us better into the policy field. Those are my initial comments.
Thank you very much. And these are supposed to be initial introductory comments. I get that of Bright Simmons, and then we'll come to Dr. Isaac Mensah-Bonsu. Now, Mrs. Simmons, what do you say about the significance of the theme for this symposium, as far as you're concerned?
Which is law that works.
Right.
So, I mean, as is probably very obvious to everyone, I'm not a legal academic, and I have also never had the privilege of serving in government. So I can't say that I have any real experience of making policy. What I have done for many years, though, is to agitate against those who do so. And I've been part of an alliance on Facebook of almost anti-lawyers, which is those of us who feel that sometimes there is an excessive focus on legalism and not enough discussion from the perspective of other disciplines, whether it's political science, sociology, etc. What I will argue is that there has been a long-standing dispute in the social sciences, at least since I last took interest. I don't know whether it's been resolved, between culture and system, whether there is a tension between the two. And an argument is often made that when you take certain societies and you pick up their laws, sometimes you don't see that much that is substantively different. So maybe if you pick up the North Korean constitution, yes, you will see some fundamental differences. But if you were to go to, say, Indonesia, and were to pick up the constitution of Indonesia as well as some subsidiary legislation, and were to compare that to the United States, on the plain face of it, there may not be significant differences in intent, in nobility, in dignity, etc. And yet, there does appear to be a legal culture, and what Prof hinted regarding the internal relations among social classes in a particular society, that changes the aspirations of the people in terms of what they want that legal system to achieve. So the legal system is there, and I think technically it's quite dry and technical. But what is the culture within which that legal system is operating? And what are the aspirations, therefore, that get set for that legal system? That is a very important point. I am reminded of the words of a particular philosopher that I discovered about a decade ago, called Carl Schmitt. So Schmitt was a Nazi, but he didn't write like a typical Nazi. I think he was a very profound thinker. And he argued that, why don't we do everything by law? I mean, you simply make laws for everything. How you bath, how you spend government money. You could do everything by laws. Somehow we seem to want to leave some discretion for policy. Why really? And I've seen on Facebook many times when some very eminent legal personalities in Ghana, at the least provocation, will say, oh, they should pass a law for it, or we should develop a law for it. And I think it's also part now of our political culture that every time there's a problem, we want to pass a law for it. I think laws are important and laws are great. But the nature of the society within which those laws are passed and the legal systems also determines the pace of enforcement of those laws. And that's why Carl Schmitt makes the argument that politics is about the exception. Law is about the routine. So when things have occurred for centuries and we are quite clear, we have a consensus in the society of how to proceed, law is perfect. The difficulty arises when someone must say this is an exception to what we've known all along. His argument was that who has the right to make that exception? To call that this requires an exception to what we've routinely known. If we take that and we develop it further, I'll argue that very often our challenge in Ghana has been that, quite apart from public choice theory, meaning that the vast majority of us don't know the laws, and quite sadly, maybe a lot of actual policymakers and people in authority also not knowing the laws, a bigger difficulty is that we live in a culture where the legal system appears to have diverged from the common aspirations of the people. So not only am I talking about the standard issues around access to legal service and the rest, but I'm talking also about the way we think. Whether the way that we think around things like litigation and the rest of it enables a society where the culture has advanced to the point where the law can become revolutionary, where the law is no longer about the routine, but it's constantly about changing the nature of society around fairness, justice, probity, due process, etc. I think that is a challenge.
Mr. Abotsi, I would like you to comment about what he just said in relation to our attitude to the law and how it is influenced by some form of the culture. But before you do that, I'd like to hear from Dr. Mensah-Bonsu. And at the NDP, do you find any difference between law and policy? You are speaking about one of the major drivers of the 40-year development plan being attitudinal change. In Ghana presently, latest 2012, we passed a law that says that when you litter, you are liable to 3,000 Ghana cedis maximum as a fine, or you could go to jail for 3 years or for both. Yet, we are presently busy seeking to pass a law to compel people to do communal labor because our society is dirty. From where you sit, do you see a difference between policy and law?
Thank you very much. Now the question is, what is policy? Just last Friday, we ended a 3-week section with all ministries, departments, and agencies in the country, here in this same hall, where we invited them to come and share with us their policies for the next 3 years, so that it will form the basis for the preparation of the national budget. So, see, if you talk of policy, it's about everything. Now, for us at NDPC, we believe that development, when you talk of development or development policy, it has economic aspects. So you can say economic policy. It has spatial aspects. So you can talk about spatial development policy. It has governance aspects. So you can have a policy on that. And you have environment aspects. So you can talk about environmental policy. It has social aspects. You can talk about social development policy. So if you talk of policy, it means everything about the human being, the development of the human being, or the welfare of the human being. Now, if you look at the development of every nation, it is a multi-stakeholder enterprise. Lawyers, doctors, engineers, name it, all the professionals, including the market women. But the question is, if we are left to do our own things, then what will be the end result? It will be chaotic. And that is why we need to have a policy that will direct all the multi-stakeholders so that we can have a consistent approach to the development of the nation. And that is where NDPC comes in. And as there are lawyers here, as it was rightly pointed out, the Constitution says that there should be a National Development Planning Commission that will advise the President in matters of development policy, planning, and strategy. And that is what we are up to. That we believe that before we can make progress as a nation, there should be a policy that will guide every stakeholder in the nation, whether they are in the judiciary, whether they are in politics, that will direct our efforts so that we can have synergy in the approach to the way we do things. Now, if you look at attitudinal change, which we said is one of the critical things we need to address if Ghana should be where we want to be. Now, before people will change their attitude, there are certain things that needs to happen. One of them could be education, or they should have the knowledge. Perhaps they are doing certain things because they are not aware of the consequences, the health consequences, the political consequences. So for such people, if you provide them with knowledge or education, they can change their attitude. There are some who can change their attitude when they have other options. For instance, you are walking around and just you look around, you see no one coming, you start wee-weeing, sorry to use that word, urinating. Why? Because perhaps the person needs to obey nature's call. There are no options. What should the person do? The person will not keep it and die or get kidney stones or something. He will do it because there's no option. So for such people, if you make options available to them in terms of infrastructure, they will change their attitude. But for some, whether they have the knowledge or the infrastructure, they decided that that is the way we will go. For such people, we have to force them. And that is where the law comes in. That there should be a law. But then, the law can be there. And people will still not change their attitude because of lack of enforcement. And that's the question. So how can we enforce compliance with laws that have been enacted in the country? And that is another challenge. And to me, to ensure compliance with laws and regulations, certain things need to happen. First of all, the laws should be enforceable. And then another one is the fact that people should be aware that they'll be caught if they infringe upon the law. But if they think that no one will see it, they'll infringe upon the law and go scot-free. And then some will also not comply because they know that even when they are caught, they can get away with it. So that way, we cannot enforce it. You see, so it's the whole lifestyle and ability to force people to do what we think is right in public interest or in national interest, so that we can have the United States.
Right, and please keep the end in mind. What are we doing wrong and how are we to get it right? Laws that work. So if you are getting your questions, write them down, but be directed by the end that we have in mind. What are we doing wrong and what are we expected to do to get it right so that we have laws that work? I know there are those who make the argument that we really have laws that work, just that those who are supposed to ensure they work are not doing their work. The minority leader made a statement, and in the statement referred to the responsibility of Parliament in a gatekeeping role of the executive. And he made an admission that they are not effectively, fully exercising those responsibilities, particularly in controlling the government purse. What is the problem? The law is there, but why is it not working? Now, your brief comments in reaction to what Mr. Bryce Simmons said, and when you are done with that, the substantive question to you as part of this process is, what would you say, for example, to those who say the Constitution that you have referred to 100 times as you made your presentation, and you are so excited about what the Supreme Court has had to do about it, some say it's a mere collection of advice, nothing more, nothing less. The Speaker of Parliament was held by the court to have violated the Constitution. That was the end of the story.
Thank you, Samson. First of all, let me just pay tribute also to Professor Akilagpa Sawyer, whom I'm very excited to share the stage with. Professor Sawyer led the Ghanaian team, if I'm right, from what I heard, on the VALCO negotiation or renegotiation. The VALCO renegotiation team. I want to put this in a very practical context. I was much younger. We had heard all kinds of things. He led the Ghanaian delegation, and today, the average person who has information on that transaction praises him for what he was able to do for the Ghanaian team. He demonstrated an attachment to a national interest. I think I'm just trying to put this in a practical context from what you said, Bright. He had a concept of competition. This is Ghana. This is his side. and that is the American and the other side. And he defended the Ghanaian side. The alternative, which he could have engaged in, which we don't think about often, is that he could have accepted a few offers from the other side. Those offers could have fundamentally transformed his personal circumstances, but they would have undermined our collective future for the rest of our lives. I say this because I believe, and I'm sure many of us in this room believe, and politicians should work towards curing that belief, that far too often, politicians look at their personal party side and compromise the national side. There is the perception among many people that the governance of Ghana has been hijacked by those who have the opportunity of politics. I think we can't deny this. And very often when we sit on stage like this, we are all too nice and diplomatic, and we dance around things, and we don't say things, and we all go to bed. Today, I think I'll get in trouble if I get out. I've said a few things, and I continue saying them. But unfortunately, somebody has to say them. Laws are about interventions. Laws are designed to cure mischief. Niccolo Machiavelli, well known by many people, said something some time ago that everybody who is a reformer has an enemy in those who stand to lose from the reform. Anytime you are embarking on a reform, there are people who stand to lose from that reform. They are the beneficiaries of the status quo. Invariably, you become an enemy. So anytime laws are passed, there are losers. There are gainers. The gainers are probably all of us collectively. The losers are the beneficiaries of the status quo, which is a mischief, which has been corrected. These guys benefit from substantially what has been called rent-seeking. Many people in positions in this country don't see themselves as public servants or servants in whichever capacity. They are lords. The reason it's called rent-seeking is because when you are a lord, like a landlord, you take rent when it's appropriate. Many of us have been to government ministries, agencies, departments, and others. And we know that these days, bribery and corruption, there's nothing shameful about it. Time was when it was hidden, and the understanding is that you're the one going to pay, you should know what to do. Nobody's going to ask you. Now you are asked. The one asking you has no sense of shame. It arises from two options. One, when you commit an offense for so long, the offense begins to look like good. And that's what happens. There are many people who have committed so many offenses. They've done it for so long that they have no sense of what they're doing being wrong. It's okay to do it. But the second option is that there's actually a sense of entitlement. Do you know how hard I worked to get to this position? I'm entitled to receive this payment. I am a director, I am whatever in this position because it is my time. And therefore you have to pay for it. Rent-seeking is the most dangerous aspect of our corruption today. The psyche of corruption has ceased to be a bad thing in the minds of people who engage in it. In the minds of those people, they are entitled to do it. And those who are the minority who are not doing it are now seen as the fools because they do not know what is right for them. And your own parents in the villages will start suddenly getting angry with you because when your friend got in that position, he built 4 houses. You have not even built one. That mentality. So the question of what laws work. We can't resolve the problem without resolving the underlying problems. And the question of culture is fundamental to it because rent-seeking is quintessentially cultural. The mentality. The reason somebody elsewhere in another country will not see it as, will not engage in that is because he believes he is there to serve. But here, the belief is that you are actually there to benefit yourself and to take rent, which you're entitled to. But the last point I make, and the most dangerous part of this, and I think that is the bane of this country before we overcome corruption, is the fact that there is no sense of common responsibility. When we lose the sense of common responsibility, I guarantee you, there's a race to the bottom. What we are experiencing today is a race to the bottom. There's a sense that from the very top, people are stealing. You know, the herd mentality, as they call it. When, you see people running, sometimes they ask questions while you're running. As you get out, you see a lot of people running in a certain direction. I'm sure none of us is going to run in the direction from which they're running. We'll all follow we'll start running before we ask, why are we running? There are many people in Ghana who are stealing today, who are corrupt today, not because they want to be corrupt, but there's a psyche of corruption, there's an environment of corruption, there's a belief in corruption, that you are either part of the group or you are a minority. And because of the belief that if I do the right thing, The people at the top are doing the wrong thing. Why should I do the right thing? Let me also do the wrong thing. Why should I do the right thing when people who have the greatest responsibility are doing nothing? And take the example of traffic. You see today, and I've told my students very often, that if you want to violate traffic rules, there are a few conditions. Number 1, buy a 4-wheel drive. Number 2, make sure it's black. Number 3, make sure it has tinted glass. Number 4, make sure the hazard works. And number 5, put on the headlights. Number 5, or 6. Number 6, have the boldness. Sorry, this one I have to use the word. But have the boldness of a fool. Driving the opposite of traffic. Because the boldness of a fool, there could be a danger, another guy coming who doesn't care, who may drive into you. But so have a certain boldness you don't care about and drive in the opposite direction. When you get to where the policeman is, I guarantee you, he will stop the others and ask you to move. These days, they don't even check. They don't even check who's in the car. So all you need is to have these conditions right. So people don't have the sense of common responsibility. They think they do the right thing. The majority are doing the wrong thing. They better join the majority.
Let me bring in Prof at this point. We'll return to that question about what the Constitution itself represents. In fact, the Constitution Review Commission that we spent over $7 million on produced a document they call From a Political to a Development Constitution. Prof, Bryce Simmons raises a fundamental issue. I don't know what your comment about it is. How much of the laws don't work because those who have the privilege of understanding the laws feel it is their preserve, and that making everybody else understand it, bringing the law to the level that every ordinary Ghanaian can understand, is not good for their business?
Well, in a sense, I try not to go down that route. Yet, fundamentally, without going down that route, we don't answer the question. The idea of the law is that it is, in a sense, an instrument. I mean, laws generally are part of the normative structures that we have. The distinguishing feature of the law amongst the normative systems is that it is state-backed. It is the state backing for the law that distinguishes it from the religious norms, from the customary rules, and so on. Once you look at it from that perspective, you are driven back to the state and its interest in the laws it passes and in enforcing them. Once you go back to the state, you are back into the power situation. Who controls the power and in whose interest is it to enforce or not to enforce the laws? As I listen to Mr. Abotsi's account of the state of corruption, what strikes me is the way in which we have come to accept so much corruption as normal, to the point where very well-meaning people behave corruptly, quite unaware that what they're doing is in any way corrupt or wrong. So we are now seeing a situation in which the laws remain, but the perception of their import has been mediated by the acceptance over a period of what would have thought was wrongdoing. I was slow to go this way because it is incomplete. We require a much more detailed discussion of the composition of power. Who controls power and what conditions? What interests do they advance? And that will take you back to the point that you were talking about earlier, the degree to which the power structures internally respond to internal pressures or external pressures. The degree to which the leadership in a country identifies with the interests of outsiders as theirs. That gets very, very complicated. And I think if you don't have that analysis in mind. You discuss the law and culture and policy as abstractions with no meaning, which is why we have laws which are on the books but don't work. We all know it and carry on. We have laws which ought to be passed but are not passed because there are, if you like, non-legal limitations on the law itself. So when Bright attacks all lawyers, it's not us the problem. We reflect the society in which we live.
Right. Now, Bright, indulge me. I'd like to read this portion of this law,
Yes.
which was made in 1979. And there is no history of this law having been used once. And I want you, from where you sit, to answer the question, is it the laws that don't work, or those who are supposed to make the laws work that are the problem? I'm referring to the Government Contracts Protection Act, 1979. It's an AFRCD 58. And it reads, penalty for issuing false certificates in respect of government contracts. Prof spoke about contracts, and we know it's a huge area where most of the corruption happens. Any person who is responsible for the issue of any certificate on the basis of which any money has been paid out of public funds to or for the benefit of any contractor or other person in respect of any government contract shall be jointly and severally liable with that contractor or other person for the refund of any money so paid to the government, statutory corporation, or other government agency of government by or on behalf of which the money was paid, or to any other authority directed in writing by the government. Now, it talks about the sanctions if you are guilty of any of this. Criminal penalties. Without prejudice to the civil liability created by Section 1 of the decree, any person guilty of any conduct described in that section, and also any contractor or other person who knowingly accepts any payment made in any of the circumstances described in that section, shall be guilty of an offense and liable in summary conviction to a fine not exceeding 3 times the extent of the improper payment. We are familiar with mere refund of monies which have been found to be corruptly received money. You refund the money without interest. In the Wyoming matter, there's no interest. In the bus rebranding, there's no any interest. Nothing comes in. Now, this law says you shall pay 3 times that amount, and you may suffer a prison term not exceeding 10 years or both. Is it our laws that don't work, or we, those who are supposed to enforce them, are the ones to blame?
So when you look at this particular extract you've just read, and you think carefully about the situation at play here, it may occur to you to look a bit deeper than purely the law, which is the earlier point that I made. What is the sociology within the society that creates the culture in which that law is enforced? Earlier on, I had a slide up by Habermas, and funny enough, his most famous quote was not on there. And this is the point about the crisis of legitimacy. The problem is that very often, without a certain consensus, or at least an elite consensus, going back to the point about social class, about what is legitimate, purely making law on the basis of the fact, particularly if it's mimicry, because other people make laws that look like this. So we also make laws that look like this. So we have laws against corruption in every society on earth. And therefore, Ghana must have an anti-corruption law. But the truth is, if you're an economist and you talk to economists, they will be surprised you with their perspective on corruption. One economist have described corruption as neutral, in the sense that it undermines both good law and bad law. What does he mean by that, really? I don't agree, but he has an insight. What he means is that if I go to the passport office and I need a passport, and I've satisfied all the requirements of the passport, and the man says, if you give me 100 cedis, I'll give you express, and I pay that 100 cedis. If I take the passport and I travel and I go and do business that benefits the country, it's a net positive. Some of you will shrink at it. That's why I said I'm going very perverse. I mean, those who are lawyers, they will say, what did he really just say? But the truth is that sometimes these probes are very important for us to understand what are the fundamental logical constructs underneath what we are proposing to change. If corruption undermines both good law and bad law, then the question is that, does it throw a spotlight on law? I think the corruption that is rampant at the DVLA, the corruption that is rampant at the passport office, the corruption that is rampant in any department of state that delivers services is a probe to the inefficiencies of the original setup of those institutions. That's what it's telling us. It's just that we are stubborn. And we keep thinking that by changing directors left, right, and center, and making national pronouncements, and we would change the corrupt nature of the institutions. You won't until you reform the institutions fundamentally. So the question I want to ask, rather the answer I want to give, is when we look deeper, what are the reforms about our society? Do these clear examples of corruption suggest? If, for instance, there are contracting laws that are being breached, in the case that you mentioned about a certificate that perhaps somebody has forged or misrepresented in order to enable some contractor who hasn't done his work to collect his money. Let me ask you a question. If you don't have performance standards in a country that is several hundred, we've been a contiguous country now for more than 100 years, and we've had complete control of our own affairs for more than 50. We still don't have even basic performance standards for ministers of state and for civil servants, living civil servants. So I appoint you as chief director at the Ministry of Agriculture. I don't say here are your KPIs, and 80% of your salary is tied to your KPIs. I appoint you as director of legal services at the Ghana Police Service, and I don't tell you that if in 3 years you don't cut down the amount of time it takes to initiation of prosecution to whatever it is, I'm going to reduce the amount of budgetary allocation I make to you. I don't make any effort whatsoever to measure performance. But I keep on every time, every moment I get in the sunlight, shouting about corruption. It becomes like a spiritual church. So, we all go in a procession, talking about corruption up and down. What are the fundamental reforms of our society around performance that will make it possible for me to say, this contractor didn't do a good job? Take a good example of the Smarty scandal that somebody mentioned, which my friend here, my elder brother here, is very involved in now. The truth is, we don't have performance standards in the execution of any government job. So because we don't have performance standards in the execution of any government job, if I come and tell you that I dance around the bus, and every time I dance around the bus, it's 100,000 cedis, and that's what I put in the invoice. You may make an argument that is not reasonable, and I know lawyers are very good at that and saying this is not reasonable, this is not this. But truly, if we were to watch performance standards in ministries, departments, and agencies in Ghana, we will catch a lot of the corrupt activities before they happen. Performance lacks and underperformance is often a leading indicator of likely corruption. Let me explain. If you go and do what we've been seeing in Ghana, where we decide that we want to transform this country into an industrialized country, and because we want to transform this country into an industrialized country, we are going to create an industrial park in Takoradi, Sekondi Takoradi. This industrialized park will be provided with utilities and infrastructure so that when you produce there, you are competitive. And it will cost us about $1 billion. We are going to borrow money from China. We will put $150 million into that project. Everybody understands Ghana has to industrialize. Policy-wise, everything is set. Then you go and appoint as your lead contractor for that project a company in China that completely, on the most basic due diligence, will not qualify in China to be allowed to build one latrine. And you appoint this company and bring it to Ghana to set up the Sekondi industrial estate. And then 8 years, or is it 6 years down the line, we don't have the Sekondi industrial estate. But you are still head of that agency in government. You are telling me seriously that this person, if somebody else goes to him and say, oh, your thing, I can put something there, but we have to collect something from the government that's $10 million to start it, and I'll pocket $2 million. Why would he not do it? Because at the end of the day, when he did nothing, for 6 years, nothing happened to him. So I feel that sometimes this inability to focus also on the surrounding context, particularly in this case, the issue of reform of state institutions around performance, It's what leads to the corruption. Now, you don't tackle that, but you keep passing laws and building institutions. You set up a shraj to be in charge of administrative justice. But you live in a country where basic guidelines around time management are unenforceable. Let me give you an example. You go to a ministry today, you present a proposal, you have a meeting with the minister. He tells you come back 2 weeks. You go, the minister sits down with you, and he doesn't remember anything that was said 2 weeks ago. Why? He doesn't have a diary secretary. If he has a secretary, he was not there in the meeting. No minutes were taken. They don't remember your proposal. I have seen it countless times, where they simply do not have the most basic management tools, and they are running the ministry. Then you say this person is there and is collecting bribe. He's collecting bribe because that has become his raison d'être. When he gets up in the morning, he's not being measured on performance. So he might as well be measured on the personal indicators of his personal success. To me, we have to be more fundamental than simply passing laws and building institutions. Because unless we reform the very roots of the society, the laws won't change much.
Right. And in his presentation to the question, he provides a number of concrete solutions, including performance standards and guidelines that are required for the basic things that ought to be done. Can we hear Professor?
Once again. Extremely interesting analysis. But the we that you use, who is it?
Good question.
Who will do the standards? Who will enforce? Who will make sure that they enforce? Because there are instances where there are standards which are clear, which are being breached regularly. So this is the lack of standards. It's a lack of enforcement. Question, who is the enforcer? Who did it? That's what I was trying to say about the class thing in the first place.
Mind to 1 second. Bright is a good friend, and we share, we hardly disagree. I don't disagree here, but I think that your legal skepticism, it's the same characteristic of the 1979 era. There's a certain skepticism towards lawyers because we tend to, defend and, many people think we are the reason for society's problems. Shakespeare even thought the same way. But the point I'm going to make is the reason laws, and I'm not one of the people who suggest there should be more laws, but I think there's a reason why laws tend to dominate. The reason is law objectifies things, takes things from the individual preferences level and puts them at an objective level. The problem is not the law. The problem is the we, as Prof was trying to clarify earlier. The problem may be the we. Let's be real about this. One of the problems of corruption for me is the name corruption.
It's what?
It's the name.
Name corruption.
The name corruption, in the olden days, they call it Christian name. What's your Christian name? Corruption is a Christian name. It's a nice name. When you call it stealing, which is the original name, it changes the dynamic. That is why a corrupt politician, a corrupt businessman, a corrupt Ghanaian may go through courts, and if he's very unlucky, he gets a small sentence because he indulged in corruption. $50 million plus, he gets a small penalty. If he gets into court, he is prosecuted by the Attorney General's Department for stealing, he gets an ultimate punishment. Now, there's something about name. Etymology is very fundamental in this respect. A name brings into focus not only the damned character of the offense, but also the public outreach by reason of which they have characterized the way they've characterized it. I think today, if you call me corrupt, I'll sleep overnight, I'll be fine. If you call me a thief, I'll have a problem.
But that depends on the values of the society. Because when you listen to radio nowadays, they're actually calling each other thieves. I mean, they've gone beyond thieves and using more unsavory words. But it's not making as much a difference.
Right. Mr. Abotsi, I want to start with you to move on to Dr. Isaac Mensah-Bonsu on the question I asked earlier. That is the general perception within a very good section of the Ghanaian society, that the laws, particularly the Constitution, is largely a collection of advice. And that is part of the problem.
Samson, all laws are in their character, advice is probably a weaker word, but all laws are in their character more or less orders. And advice, it's less than an order, but it's more of telling you what to do for the future. So that's what all laws are everywhere in the world. The Constitution is the same character. The Constitution tells us what we should do, what we shouldn't do, which institutions we should build, what we shouldn't build. Some penalties in some cases, such as when you commit a coup d'etat, you attempt a coup d'etat. And then prescriptions, such as policy blueprints under the directive principles of state policy. It's a combination of things, and it reflects our history, such as the transitional provisions, among others. So the Constitution is a collection of various things. You can call it advice. It certainly is beyond advice. Things have been struck down.
Sorry, but what they are looking at is, for example, the example that the minority
I'll
leader
come
gave,
there.
that
Right.
in the Constitution, they have a financial oversight on the executive. And yet, we have had election years, and they completely have not, they are unable to do anything. Meanwhile, the law expects them, the Constitution expects them to hold the executive to spend within the budget.
Right.
What are the sanctions? The Constitution doesn't say.
The Constitution has done what it has to do. And I have to say it here. The Constitution Review Commission done a fantastic job. With or without it, Ghana would have still been evolving. The problem is us. Again, the us, the we that was used earlier. Look at the Constitution carefully. It is a model Constitution. Our Constitution is far better than the American Constitution. I'm telling you. The American Constitution is about a quarter of our Constitution in terms of comprehensiveness.
And the British?
And they have none, according to records. But the reality is that human ingenuity, sometimes negative ingenuity, is a step ahead of the law. So you can make the best laws, invariably people will undermine it. So the reality is this. As we have in the Constitution, if the Constitution makes a prescription that if something happens, another consequence should take place, you need the human activity to put this in action. Invariably, the human activity part doesn't happen. Invariably, you have negative institutional relationships. The problem we have, and with the greatest respect, most honorable Mensah-Bonsu, with the greatest respect, I think he himself, actually, he led the discussion, and thank you very much for that, because he actually exposed the parliamentary part for the discussion. The centerpiece of our entire constitutional architecture is Parliament. Everything, not the courts. Many people think the judiciary, but not the judiciary. Parliament is the centerpiece. All the accountability instruments are inbuilt there. The problem we have is that we have a party system that creates patronage. We have a party system in which the party in Parliament sees its responsibility as maintaining the party in government. That is the problem. So you have the party in Parliament. The Constitution doesn't know parties in Parliament. The Constitution only mentions parties when it comes to crossing carpet, among others. Otherwise, the Constitution sees Parliament as a corporate entity and deals with Parliament as Parliament. Unfortunately, we have a fragmented Parliament which constantly the opposition sees itself as a way of helping the party outside to win power and therefore more or less undermine, or that's the perception. But the party in Parliament sees itself as holding the forts for the government, the one in the executive. And therefore, everything coming to Parliament, they don't see themselves as Parliament, they see themselves as holding the fort and protecting. That is the problem. So, as you're asking, whether these are advisory, whether Parliament would go ahead and pass the requisite laws and do all it has to do, the law, you can pass the best of laws if you have people who do not have the willingness. As Carl Friedrich said, the willingness to stay within the boundaries of power is the essence of constitutionalism. It is not the law. If the person has no desire, we'll dance around it. We'll find a nice way of dancing around it. How many times can you go to courts?
Okay, thank you very much. And Bright has his hand up, but please wait for me a moment. Dr. Mensah-Bonsu, the project, very nice project that you are embarking on, and I don't want to say you, it is all of us, it is in our interest that we have, connected development at each point, of the time that political power changes. But if our laws don't work, that project will be in vain. What are your, solutions that you proffer for us to have our laws working?
Thank you very much. I made reference to the CRC report, the Constitution Review Commission report. Those of you who have read the report, they indicated that when they went around consulting Ghanaians, they went with 34 issues. Planning and NDPC wasn't part. But wherever they went, what they heard was that as a nation, we need a long-term development blueprint. that all will follow, including successive governments, to ensure that we move in a consistent manner towards the achievement of the goals of the Constitution. I remember you also quoted it, that they are thinking of a developmental constitution. So that's the question. Everything that we do, law, what is the objective? Where should it end us? But I believe that everything should move towards the development of people, the development of the Ghanaian. And that is why I personally think that the Constitution and the laws and everything that we talk about should promote the development of the people. And I also believe that in formulating laws, we have to take advantage of the expertise in the sectors where the laws are being made. If it is an environmental law, you have to make sure that we include experts in experts in environment, so that they will provide the technical, instruments that the lawyers can also, use to formulate the laws. Now back to the question of the long-term plan that we are preparing. The Constitution Review Commission recommended that it should be enacted into law. And if it's enacted into law, any Ghanaian can compel the government to implement it.
All right.
So that is what.
Okay.
But finally, the white paper that came out did not accept that recommendation.
Right.
But I know that the implementation committee has been considering the recommendation from the CS, the original recommendation.
Thank you. Can we hear Bright had some reaction?
I was just going to say that the combined effect of the statements Prof made and Mr. Abotsi made is that invariably it's about people. If we are not careful though, and though that's very persuasive, if you are not careful, it takes us down the path of some kind of socio-biological determinism, which is to say that Ghanaians just are not here. Yes, still, you have the same Ghanaians and you take them to the United States, you take them to Germany, you take them to France, and somehow they behave differently. When they are in the courts, they behave differently. When they are somewhere else, they behave different. That tells you something deeper is at root. And to me, unless we can identify that deeper context, and to me, unless we can narrow down on this notion of pluralistic competition among factions within the society, and do everything we can to engender it, civil society, highly active, activists, etc., we will not get to the root of it. Because I think Ghanaians as human beings are no different from Americans, Germans, or Chinese. So how come they are not enforcing their laws?
But that's what I mentioned.
Okay, thank you very much. Let's take a few questions from the members of the audience. Please, if you have any question, put up your hand and the microphone will come to you. So,
while waiting for the question, though, I mean,
right. Okay.
Just for the benefit of
the microphone. Yeah.
Well, while waiting for the microphone, though, just for the benefit of time, the race to the bottom mentality I mentioned, I still think it's critical. That's one of the solutions, or rather the problems I identified. Is the race to the bottom thing. The American thing, I've thought about the same way too. The reason the guy will go to work, even though there's a snowstorm, is because he knows that will not be countenanced as a reason for not coming to work.